All right, welcome back to part 2 of chapter 10, where we were talking about pretrial and trial procedures. And we're going to we're staying with charging the defendant, but we're going to start to move into the actual process as it relates, and we get closer to trial, if you will. So we talked a lot about the indictment process, right? The grand jury. We talked a lot about the information process. Remember, that's the preliminary hearing. And we went over those kind of in detail, so you should be pretty set on both of those. Now, after an indictment or information is filed following a grand jury or a preliminary hearing, right? Because there could be either or. An arraignment takes place before the court that will try the case. And at the arraignment, the defendant is informed of the charges against them and and the court will appoint counsel if one has not yet been retained. And you'll also, at this particular stage, you will enter a plea. So it's going to be one of three typically. First would be guilty, which means that I committed the crime, and more than 90% of defendants appearing before the courts plead guilty prior to a trial. Next would be not guilty, which means I did not commit the crime, and if that plea is entered, then a trial date will be set. And then the last one will be what they call no contest or nolo contendere. Now, a plea of nolo contender or nolo contendere is essentially a plea of guilty. The plea has the same consequences as a guilty plea with one exception. The plea may not be held against the defendant in a subsequent civil trial because there's no admission of guilt. You're not pleading guilty, you're pleading nolo. And hopefully that kind of makes sense, because we know that you can be tried in civil court and in criminal court, but if you plead nolo, you're still pleading guilty. But because you're not actually entering a guilty plea, it's the same as a guilty plea, but because you're not actually entering a guilty plea, that plea can't be held against you in a subsequent civil trial. Okay, and also keep in mind that, most cases never go to trial but are bargained out of the system. And this is going to kind of fall into our plea bargaining discussion, if you will. And a defendant who enters a plea bargain waives three very important rights. The first is within the Fifth Amendment, which is the right against self-incrimination. The next one is in the Sixth Amendment, which is the right to a criminal trial. And then finally, another one within the Sixth Amendment, which is the right of a defendant to confront the witnesses against him or her. And because of a plea bargain, you're essentially going to enter a guilty plea, but you're going to waive these rights as part of that plea bargain. So hopefully that kind of makes sense. So again, most cases never go to trial but are bargained out of the system. More than 90%, okay, of criminal convictions result from a negotiated plea bargain. So it's a legal process that involves the defense attorney, the prosecuting attorney, and the approval of the judge. Now, the data shows that plea bargains help both the prosecution, which is assured of a conviction, right, and the defendant, who is rewarded with a more lenient sentence or lesser charges or whatever the plea bargain actually turns out to be. Okay, so that's a little bit more on the essence of plea bargaining. So plea bargains, what can they be made for? Well, just to kind of give you a little bit more, a plea of guilty in exchange for what? So it could be a reduced sentence. It could be dropping a couple of charges. Say you have 3 charges of burglary, but they're going to drop one. It could be lowering the charges from a higher felony to maybe a misdemeanor. or substituting a negative charge for one with a more socially acceptable connotation, like maybe a plea bargain for, instead of DUI, it could be, some other type of charge, like reckless driving or something. So, I mean, these are examples. And on the right, I have a little kind of a screenshot from the Pew Research Center that talk about the fact that trials are rare in the federal criminal justice system and, of course, in the state. But you can also see the amount of cases here. And then we're talking about federal here, but 90% pleaded guilty. Okay. So just kind of an interesting thing, but plea bargains, there is a place for them, but we also need to understand that there can be some pressure to accept a plea bargain as well. A lot of times these plea bargains are kind of like a one-shot thing. And it could be that you might feel pressured. It could be a roll of the dice, right? If you're looking at, let's say you're looking at 10 years in prison, but yet they offer you a plea bargain for 3 years. If you go to trial and you lose, you could get 10, but if you take the plea bargain, you could get 3, but what if you didn't do it? So you can kind of see that there could be some pressure to, take a plea bargain. So what are the pros and cons then of plea bargaining? Well, the pros are the overall costs of the criminal prosecution are reduced. The administrative efficiency of the courts is improved, right? There's not all these backlog cases. The prosecution can devote more time to more serious cases. The defendant avoids possible detention and an extended trial and may receive a reduced sentence. And then resources can be devoted more efficiently to cases that need greater attention. So these are just some of the, those that are proponents contend that plea bargaining actually benefits both the state and the defendant in some of these ways right here. Well, what are the cons then? So opponents of plea bargaining or that process believe that a negotiated plea should be eliminated for the following reason. Okay, but we're going to kind of take a look at it. First of all, it basically encourages defendants to waive their constitutional right to trial. Plea bargaining allows dangerous offenders to receive more lenient sentences. Plea bargaining also raises the danger that an innocent person could be convicted of a crime if they are convinced that the lighter treatment ensured by that guilty plea is preferable to the risk of conviction, right? So that's that 50-50 that I kind of told you of, that roll of the dice, right? Hey, I'll take the plea because it's better than going to trial and if I lose. Prosecutors are also given a free hand to induce or compel defendants to take a plea bargain, thus kind of circumventing that process. It is possible that innocent persons will admit guilt if they believe the system is biased, and they'll have little chance of being acquitted. And, a guilty plea culture has developed among defense lawyers. Elements of this attitude include the belief that most of their clients are dishonest individuals who committed the crime with which they've been charged, and getting kind of a sentence discount, if you will, for them is the best way, or maybe even the only way out of it. So these are some different things. And then finally, you talk a little bit about, a defendant's race is relevant in plea bargaining. One study found that Black and Latino defendants were less likely than white defendants to receive, reduced charge offers. So there are all of these issues. So these are the kind of the opponent's version of why plea bargaining may not be the best. Now, despite these issues, it is unlikely that plea negotiations will be eliminated or severely curtailed in the near future, because there is a reason for plea bargaining. So there are some benefits, but of course, there are drawbacks, right? Okay, so now let's move on to what we call the problem of false confessions. So it is certainly not desirable to have an otherwise innocent offender plead guilty to a crime he or she did not commit simply to avoid the possibility of being found guilty at trial. Unfortunately, some defendants basically decide or conclude that they will be better off by just admitting to the crime, even if they had nothing to do with it. So the example I gave you a moment ago, why take the chance on going to trial and spending 20 years in prison when you could get that deal for 5, and if there's good time, maybe you could get out in 3, maybe even 2. So, but you didn't do it. So these are some of the issues that kind of come up, right? And this is the problem of when people might confess falsely in order to kind of reduce their case. So why do innocent people confess? And, there's a lot of thought into this. Why do innocent people confess? Well, according to the Innocence Project, there are a lot of different reasons, including duress, coercion, intoxication, diminished capacity, mental impairment. Maybe they don't know the law. They're ignorant of the law. Maybe the fear of violence, the actual infliction of harm, the threat of a really harsh sentence, or maybe even a misunderstanding of the situation. So these are all, reasons, if you will, why people might confess. And, the Norfolk 4 is a great example of individuals that confessed when they actually didn't commit the crime that they were accused of committing. And so the U.S. Supreme Court has reviewed the proprietary issues of plea bargaining in several decisions, and while imposing limits on the practice, has upheld its continued use. But the court has ruled in several key cases regarding plea bargaining. Okay, and here's kind of what they say. So these are legal issues relative to plea bargaining. So the court has ruled in several key cases that defendants are entitled to the effective assistance of counsel to protect them from pressure and influence. That pleas must be made voluntarily without pressure. That, as it relates to plea bargaining, any promise made by the prosecutor during the plea negotiation must be kept after the defendant admits guilt in open court. So you have to keep your promises, okay? Defendants must also keep their side of the bargain to receive the promise offer of leniency. A defendant's due process rights are not violated when a prosecutor threatens to basically, kind of rescind the accused on more serious charges. For example, as a habitual offender, the defendant does not plead guilty to a lesser offense. Okay, so, guilty pleas from persons who claim innocence are still valid. Accepting a guilty plea from a defendant who maintains their innocence is valid, as I just said. Statements made during a plea bargain may be used under some circumstances at trial if negotiations, kind of break down. Flawed advice from a defense attorney that leads to rejection of a plea deal can form the basis of an effective assistance counsel claim. So these are some legal issues that the U.S. Supreme Court has basically found. And you can find those on page 398 and even over on 399. Okay, so as we kind of finish up now with the plea bargaining part, what is the role of the prosecutor? Well, the prosecutor in the U.S. system of criminal justice has broad discretion in the exercise of their responsibility, and such discretion includes basically deciding whether to initiate criminal prosecution, determine the nature and number of criminal charges, and choosing whether to plea bargain a case and under what conditions. So plea bargaining is just one of the major tools that a prosecutor uses to control and influence the criminal justice system. The other two are the decision to initiate a charge and the ability to take the case to trial. Now, few states have placed limits on the discretion of prosecutors in plea bargaining situations. And, keep in mind also, a court will not accept a guilty plea unless the defendant has been properly advised by counsel and the court has determined that the plea is voluntary and has what they call a factual basis. So those two things have to be basically formed before a plea bargaining is going to be accepted. Okay? So, the role of the defense counsel in plea bargaining, we talked about the prosecution, is advisory. It's basically explanatory, meaning, I'm going to explain kind of what's going on, and it's informative. The role of the judge in plea bargaining really isn't that straightforward, but it should be more supervisory or enter into the negotiation process itself. But the judge has to approve a plea bargaining deal. I mean, you kind of think about it. Should the judge act only in a supervisory capacity or actually enter into the negotiation process? Well, the leading national legal organization, the American Bar Association, is really opposed to judicial participation in a plea negotiation. Okay, it should be just between the two counsels, right? The defense attorney and the prosecuting attorney. All right. And then what about the victim and plea bargaining? Often the victim plays no role. They're not required to be part of the process, but there's always a question, should they? What role should victims play in plea bargaining? Well, right now, crime victims are not empowered at the pretrial stage of a criminal justice process, and thus, because of that, they don't really play a role in plea bargaining, okay? Now, although plea bargaining has been criticized, efforts to control it have not been met with much success. But in, recent years, efforts have been made to convert plea bargaining into a more visible, understandable, and fair dispositional process, because it is a process that has some merit. And many jurisdictions have developed safeguards and guidelines to prevent violations of due process and to ensure that innocent individuals do not plead guilty under coercion. And here's a couple of the safeguards. Number one would be the judge questions the defendant about the facts of the guilty plea before accepting the plea. Number two, the defense counsel is present and can advise the defendant of their rights. Number three, the prosecutor and the defense attorney openly discuss the plea. And then finally, number four, full and frank information about the defendant and the offense is made available at this stage of the process. In addition, judicial supervision ensures that plea bargaining is conducted in a fair manner. So here are some kind of thoughts regarding judicial safeguards. Okay, so what are some other pretrial programs? Well, they have diversion programs. And these programs offer a criminal defendant the ability to enter a treatment program instead of a criminal trial. And this continues to be used throughout the United States. Most diversion programs have a common goal. And that goal is, to constructively bypass criminal prosecution by providing a reasonable alternative in the form of treatment, counseling, or employment programs. So these are called pretrial diversion programs. So it could be drug diversion, it could be anger management. These are all diversion programs instead of going through a lengthy trial. And if the person completes these programs, then their case is basically completed and it's dismissed. So the form of diversion programs. All right, so now we're going to talk about the trial. Okay, and we've probably been waiting for this over anything else. So the criminal trial is an open and public hearing designed to examine the facts of a case brought by the state against the accused. And criminal trials, again, are relatively rare. Most cases are settled by a plea deal during that pre-trial stage, and we've talked a lot about that. Now, by its very nature, the criminal trial is a symbol of moral authority of the state. It symbolizes the administration of objective and impartial justice. And regardless of the issues involved, the defendant's presence in a courtroom is designed to guarantee that they will have a hearing conducted under rules of procedure in an atmosphere of fair play and objectivity, and that the outcome of the hearing will be clear and definitive. Okay? And most trials that are, kind of held, most formal trials, if you will, are heard by a jury, although some defendants waive their constitutional right to a jury and request a bench trial. So here are a couple of different terms as it relates to trials. First would be a jury trial. That's a trial by jury. That kind of makes sense, right? A jury trial by jury. Typically it's 12. It depends what state you're in. It could be less. And the jury is the trier of facts. It could be a bench trial. This is a trial by judge. So while people are entitled, as I said a moment ago, that most trials are heard, by a jury, some defendants will basically waive, okay, or pass on their constitutional right to a jury trial and request that bench trial. And a bench trial is one in which the judge alone weighs the evidence and renders a verdict. Okay? Another term that you want to be familiar with would be the term of adjudication. This is the determination of guilt or innocence. It's the judgment concerning criminal charges. And then finally is the term called verdict. And the verdict would be the findings of a jury or a judge on questions of fact at a trial. So these are some terms, and we're talking again about the trial. So, what are some of the rights that you have? The legal rights during a trial. So, underlying every trial are basically constitutional principles, or even complex legal procedures, rules of court, and interpretations of statutes, all designed to ensure that the accused is going to receive a fair trial. So what are some of those principles? Well, the first would be the right to an impartial judge. And even though the Constitution does not say so, every criminal defendant is, supposed to enjoy or have the right to a trial by an impartial judge. And the Supreme Court ruled as much way back in 1927 in a case called Toomey versus Ohio. Well, what if the judge isn't impartial? How can a judge be removed? Well, generally the judge will excuse themselves if there is a conflict of interest, and we've talked a little bit about that. Judicial code of ethics provide the guidelines judges need to make on these types of decisions. We have the right to be, competent at trial. So to stand trial, a criminal defendant must be considered mentally competent, to understand the nature and extent of the trial, the proceedings. And if a defendant is considered mentally incompetent, then the trial must be postponed until treatment renders them capable of participating, in their own defense. We have the right to confront witnesses. The Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against them. The accused enjoys the right not just to be able to confront the witnesses in person, like live right there, right? But also being allowed to participate in his or her trial. That is, trials cannot be conducted without the accused being afforded the right to appear in person. So you have the right also to, you have the confrontation clause. And this is really, this kind of stays with confront witnesses. The confrontation clause basically says it's essential to a fair criminal trial because it restricts and controls the admissibility of hearsay evidence. That meaning third party, somebody heard something and I'm going to testify about it. Hearsay evidence is basically the same thing as saying secondhand rather than being told firsthand. It consists of information related by a second party, right? That's why they call it hearsay. So the framers of the Constitution envisioned face-to-face accusations, right, in which the defendant has the right to see and cross-examine that witness, that person that heard something, that person that said something. You also have the right to a compulsory process. The Sixth Amendment says that in part that the accused shall have, compulsory process for obtaining witnesses in their favor. And compulsory process, by definition, means to compel basically the production of witnesses via a subpoena. And a subpoena is an order basically requiring a witness to appear in court at a specific time and a specific place. And you also have the right to an impartial jury. So it's no accident that all of these rights guaranteed to the people by the Constitution, or it's no accident, right? Only the right to a jury trial in criminal cases appears in both the original Constitution and the Bill of Rights. And although they may have disagreed on many points, the framers did not question the wisdom of a jury trial. Okay. Today, the criminal defendant has the right to choose whether the trial will be before a judge or through a jury. And although the Sixth Amendment guarantees the defendant the right to a jury trial, the defendant can often and does often waive their right to a jury trial, and it moves to a bench trial, which is a trial by a judge. And you also have the right to counsel. So the right to counsel applies all throughout the criminal justice process. In the discussion of Miranda versus Arizona in Chapter 8, we said that the criminal suspects are to enjoy the right to counsel during custodial interrogations. And the Supreme Court recently decided that a defendant's very first appearance before a judge also triggers the right to counsel. So our focus in this section, however, is on the right to counsel at trial, but we know that they are entitled to the right to counsel at trial. And then a speedy trial. So tactics employed by these, maybe dragging your feet defense attorneys, pretrial motions, complex plea negotiations, delay tactics during trial, along with inefficiencies in the court process, such as frequently granting of continuances, poor scheduling procedures, and the abuse of time by court personnel, et cetera, have made delay in criminal cases a real serious and constitutional issue because you're entitled to that speedy trial, right? And, as the American Bar Association states, congestion in the trial courts of this country, particularly in urban centers, is currently one of the major problems of the judicial administration. And delays in the trial process, basically conflict with the Sixth Amendment's guarantee to a speedy trial. So it is important that you've got the speedy trial. You also have the right to a public trial. The Sixth Amendment refers to a public trial. This simply means that all trials must be open to the public. And the right to a public trial is generally unrestricted. Anyone who wants to see a criminal trial can basically do so. And, now there are some instances where there might be parts of a trial that might be closed due to publicity, etc., and that will be decided by the judge typically, but you have a right to a public trial. And then you have the right to be convicted by proof beyond a reasonable doubt. And that's the standard required to convict a defendant charged with a crime at the adjudicatory stage of, the criminal justice process is proof beyond a reasonable doubt. And this requirement dates back to the early American history, and over the years has become the accepted measure of persuasion by which the prosecutor must, basically convince the judge or jury of the defendant's guilt. So, proof beyond a reasonable doubt. And the reasonable doubt, standard is an essential ingredient of the criminal justice process. It is the prime instrument for reducing the risk of convictions based on, factual errors. The underlying premise of this standard is that it is better, to release a guilty person than to convict someone who is innocent. And because the defendant is presumed innocent until proved guilty under that standard, right? This standard forces the prosecution to overcome this presumption with the highest standard of proof, which is proof beyond a reasonable doubt. So a lot of information to cover. Okay, so now we're going to kind of talk a little bit about some complications, and we're going to talk a little bit, the trial process, but also talking about like juries and things. Okay, so the modern criminal trial is complicated and often time consuming, based on, its technicalities that surround it, right? And it is a structured adversarial proceeding in which the prosecution and defense follow specific procedures and argue the merits of their cases before the judge or jury. And each side seeks to present its case in its most favorable light. And when possible, the prosecutor and the defense attorney object to evidence that they consider, of course, damaging to their positions. Now, here's kind of what the trial actually looks like. I threw in a little chart talking about the trial. And part of this whole trial process is going to encompass the jury selection process. Okay? And, each side, of course, seeks to present again its case in the most favorable light. And when possible, the prosecutor and the defense attorneys, object to evidence that's damaging to their positions. As I said, the prosecutor uses what they call direct testimony, physical evidence, and confessions, if available, to convince the jury that the accused is guilty beyond a reasonable doubt. And the defense attorney rebutes the government's case with their own evidence, makes certain that the rights of the criminal defendant under the federal and state constitutions are considered during all phases of the trial, and determines whether an appeal is appropriate if the client is found guilty. Now, although each jurisdiction in the United States has its own trial procedures, all jurisdictions conduct criminal trials in generally a similar fashion. And the basic steps of the criminal trial we're going to go over right now. So as I go back here, these are the basic steps. Okay. So, you're going to have the prosecutor's opening statement to the jury, the defense's statement, the prosecutor presents evidence, defense attorney cross-examine, defense attorney's case, prosecutor cross-examine, okay? And then it kind of goes all the way down, all right, all the way to sentencing. But the first thing that happens is going to be the jury selection process. Now, part of that process is what they call voir dire. And this is the process in which a potential jury panel is questioned by the prosecution and the defense in order to select jurors who are unbiased and objective. And once the prospective jurors are chosen, the lengthy process of voir dire starts. Prospective jurors are examined under oath by the prosecution and the defense about their backgrounds, their occupations, where they live, and any possible knowledge of or interest in the case. Because this is how we're going to start to form the jury through this voir dire process. And there are a couple of things that come about. There are challenges during this jury selection. There are things called challenges for cause, and this is basically dismissal of a prospective juror by either the prosecution or defense because they're biased, because they have prior knowledge of the case, or for other reasons that demonstrate that the person is unable to render a fair and impartial judgment. And then they have what we call preemptory challenges. And this is where the attorneys can dismiss a prospective juror for either, for whatever reason they want to, for any other discretionary reason except for race. And there are limits depending upon what state you're in again. So there are unlimited challenges for cause, and 10, we're looking at California code, and 10 preemptory challenges in criminal cases, 20 in death penalty cases, and 6 in civil cases. But this just kind of gives you an example. I just want you to know the difference between challenge for cause and preemptory challenge. So hopefully that kind of makes sense. So some of the challenges in, we talk about, jury selection. The U.S. Supreme Court states the jury is to be a cross-section of the community. And for reasons, here are some reasons for this particular requirement. Okay. Decision making, common sense judgment of a cross section of the community. An impartial jury, a cross section prevents stacking the jury. Unfairness, that cross section hopefully will have a high level of fairness. So unfairness should be avoided. And then civil rights, the right to serve on a jury should be safeguarded. So all of these different things come into play as it relates to the jury. And then we talked about opening statements. So once the jury's been selected and that complaint has been read to the jury by the court clerk, the prosecution and defense can make their opening statement. And typically the prosecution goes first and then the defense will go second. And then next will be the prosecution's case. So following opening statements, the government begins their case by presenting evidence to the court through its witnesses, officers, victims, and experts. They provide testimony via what we call direct examination. During direct examination, the prosecution questions the witnesses. So by definition, direct examination, the initial questioning of one's own witness during trial. So direct examination for the prosecution, and then you'll have direct examination for the defense. So prosecution, defense, right? Makes sense. And then upon completion of the prosecutor's questioning, the defense usually conducts what we call cross-examination. And during this exchange, the defense may challenge the elements of testimony, such as the witness's accuracy in reporting what they saw, or heard. And if required, the prosecution may seek a second direct questioning. Okay. Examination after the defense has completed their cross-examination. Okay. And then if required, the defense may do a recross. So there's direct examination by the prosecutor. There's cross-examination by the defense attorney. Then there could be some redirect by the prosecuting attorney, and there could be some recross by the defense attorney. So hopefully that kind of all makes sense. So they each get to take turns, right, in questioning the witnesses, the experts, etc. And then the defense will give their case. The defense then presents its case, calling its witnesses, the same as the prosecution. Now, they don't have to present any witnesses, and the defendant doesn't have to testify. So the prosecution conducts cross-examination, right? So that if the defense calls witnesses, and when they're done, the prosecution they can ask questions, they can cross-examine. And during this exchange, they may also challenge the elements of testimony, such as the witness's accuracy in reporting what they saw, etc. So it's kind of the same thing, right, for the prosecution and the defense, the same system, if you will. And then when they're all done with that, they have closing arguments. And this is where basically the attorneys review the facts and evidence of a case in a manner favorable to their position. And at this stage of the trial, both the prosecution and the defense are permitted to draw reasonable inferences and to show how the facts basically prove or refute the defendant's guilt. After this, you have instructions to the jury. So in a criminal trial, the judge will instruct or charge the jury members on the principles of law that need to be followed and guide and control their decision on the defendant's innocence or guilt. And included in the charge will be information about the elements of the crime, the offense, the type of evidence needed to prove each element, and the burden of proof that must be met in order to obtain that guilty verdict. After this, they basically deliberate. The jury deliberates. So once the charge is given to the jury members, they retire to a location and they discuss or deliberate on the verdict. In highly publicized cases, the judge may do what they call sequester the jury, meaning they have to stay there, okay? The jury prevents them from having contact with the outside world, if you will. Now, this process is discretionary, and most judges believe that sequestering or locking up a jury is needed only in those really big, sensational type cases. When you talk about deliberation and verdict, jurors are ordinarily provided with copies of the charges again and the instructions. The judge may allow jurors to look at, different pieces of evidence that were introduced. If there's a couple of terms that you may want to know, a deadlocked jury means that they are unable to reach a verdict. A hung jury means that the jury cannot reach a verdict after deliberating for a reasonable time. So typically what will happen is you might have a hung jury first, and then basically the judge will send them back to keep deliberating. And if they just can't reach a verdict, then it's going to be a deadlocked jury, which means they just can't reach a verdict. So this is reasonable time. This is, hey, we've sat here for so much time and we just can't figure it out. There's a phrase called jury nullification. So this is a jury verdict acquitting a defendant cannot be appealed. An acquittal ordinarily is based on the decision of a jury that the prosecutor failed to present facts that establish the person's guilt beyond a reasonable doubt. Sometimes a jury may find the prosecutor proved a person was guilty beyond a reasonable doubt and still did not basically, but they refused to return that verdict of guilty. This situation comes about where the jury believes that the law is unfair or that it's under unfair circumstances. So an example would be to acquit a husband or wife who killed a dying elderly spouse or an adult child who killed a parent who was in extreme pain. This is where juries vote their conscience versus their guide. But that's, jury nullification. That's just a definition, so you know that. And then finally is the sentence. And this is, imposing the criminal sentence is usually the responsibility of the trial judge. In some jurisdictions, the jury may determine the sentence or make a recommendation involving leniency, but typically it's the judge. And the sentence itself is determined by statutory requirements for the particular crime as established by legislator. And then, of course, after the verdict, if you don't like, the verdict, etc., once a verdict has been rendered, a defendant found guilty, the defense may petition a higher court or an appellate court to review the procedure used during the trial. Defendants have two main avenues to challenge such procedures. They call it an appeal, which I just said, or what they call habeas corpus. A post-conviction appeal is a request for an appellate court to examine a lower court's decision in order to determine whether proper procedures were followed, and a writ of habeas corpus is a judicial order requesting that a person who detains another person produce that individual and give reasons why they're continually being detained. So just kind of a couple of interesting things. All right, a lot of information. I hit part 2 really quick because we were really pushing for time. So thanks for hanging with me. Again, a lot of stuff that we covered. So I appreciate your attention, and that's going to conclude part 2 of chapter 10, the pretrial and trial process and procedures.